All right, good morning, everybody. It's 9 a.m.-ish, 9:04, and hopefully you guys all got your coffee and you're ready to be woken up by conversations about AI and copyright, one of our favorite topics. AI seems to infect, or infuse, maybe a nicer word, about every topic that we discuss in law school these days. I have a few law students here I see in the audience who know what I'm talking about. I'm looking at one of them right now who helped me testify before the House Judiciary Committee and has come back to watch the panel. Let's get started. We've got a great panel lined up. Every day brings new AI developments, as I think all of you are here to attest. And even just in the last few weeks, we've had a new lawsuit against the Copyright Office filed by a visual artist, Mr. Allen, who is disappointed that the Copyright Office won't register his AI-assisted visual artworks. There's a head-spinning array of lawsuits against AI companies that are styled as class actions, challenging the use of copyrighted works as training data. There's legislation called the No Fakes Act that was dropped in both chambers of Congress in an attempt to deal with issues like digital fakes, digital replicas of our likenesses. I'm sure we're going to hear more about AI issues from Director Vidal at lunchtime, but both the USPTO and the Copyright Office are neck deep in all sorts of AI issues. And industry rumors have it that we'll be hearing or receiving more reports and recommendations, probably from both the Copyright Office and the USPTO before the end of the year. And companies and individual artists, as well as consumers, are trying to sort out what all of this means for them. So we've got this amazing panel arrayed before us here with wide experience from different sectors, from academia, from government, in their past at least, this morning. So I'm going to just give a brief cue as to who people are as I ask them the first question. And then as they speak, you'll get a sense of where they're from, what they think, and that'll be introduction enough, I think. So let's start with Karyn Temple to set the scene for us. And Karyn was the 13th Register of Copyrights. I don't know, is that a lucky number, Karyn?
Now it is.
I think so. She was the Register of Copyrights, and she's currently Senior EVP and Global General Counsel of the Motion Picture Association. And according to Billboard magazine, she's seen as being even-handed in the types of copyright issues that have become contentious in the digital age. So that's why I'm asking her to start things off this morning and to frame what she thinks the relationship between copyright and AI should be as we start the panel discussion. So maybe think about it this way, Karyn. So some of the discussions related to AI talk about AI innovation and copyright enforcement as mutually exclusive. So people say copyright enforcement is a threat to AI innovation, and generative AI poses a threat to copyright and creativity. What's your take on that?
Yes, and thank you. It's a pleasure to be here, Sandra. Just our usual caveat that I am not here in my capacity as representing my studios, but really as a academic in terms of a lover of copyright law. But you really took the words right out of my mouth. I think that I personally am an optimist, and so I think that we need now to kind of take some of the lessons of the past. For example, when the internet started and there was widespread hysteria, and avoid creating a false dichotomy, as you suggested. Avoid assuming that AI is this savior of innovation that, only can see copyright law as an obstacle. Copyright is itself, under threat, and AI somehow needs to be defeated. So I think, in the past, when, the internet and sometimes other new technologies have come onto the scene, we have, kind of it ended up going to our respective sides and not really being able to realize the potential benefits of the new technology until much, much later, until after all the litigations are finished, until, you know, both the innovation and copyright law kind of has a bad name. And I think that we should recognize now, given all of that, you know, history and all of that experience with new technologies that have come along, that copyright law actually is much more robust and flexible than we think. It has been able to deal with new technologies as they've come along. We have been able to apply copyright law in a way that does not in any way serve as a barrier or an obstacle to innovation, as long as we just apply it in a very methodical and equitable and fair and reasonable way. And where there are actual gaps, where there are actual issues that copyright law, as it currently stands, is not able to address those issues, then yes, we can consider revisions, but we should consider them, again, reasonably, you know, with the actual legal analysis and support that we need, as opposed to just a knee-jerk reaction that, oh my goodness, there's this new technology out there and it has to be regulated or stopped. And so I think that hopefully, as we are continuing to kind of deal with the rise of AI, we can do it in a way that just allows us to, again, take those experiences that we've had in the past and really take a step back, take a deep breath a little bit for some of us on the content side who can feel that, oh my goodness, here it comes again. There is this innovation or technology that's going to up in the content world. And also on the other side, technologists take a deep breath and not say copyright is the bad guy and it must be ignored. And I think, you know, there are some areas that will benefit from additional study, as we know is already going on. Issues like copyrightability, making sure that, you know, we do have appropriate guidance to really understand how we'll be able to apply the current and I think robust framework on copyrightability to this new type of technology. There might be additional areas like deep fakes and misinformation that will benefit from additional you know, tools to address, like we have in the No Fakes Act, as well as issues like transparency and, you know, increased support for licensing. So I think that the law is very flexible, it's robust, it's been through a lot, it's been battle tested, and I think that if we all take a step back and take that deep breath, we'll be able to see that AI too will be something that we'll be able to actually take advantage of, both from the content side and from the platform technology side as well.
So Karyn has framed this positive, balanced vision of AI for us, and I can't help but notice that Joshua Simmons has been seated next to her, and Joshua is a litigation partner at the firm of Kirkland and Ellis, and he gets lauded in the legal press and you know, places like Chambers or Law 360 or American Lawyer with superlatives, calling him like power lawyer and a trailblazer and a lion of the law, and I think somebody's actually called you a legal dragon or something. I don't know. He doesn't look very dragon-like to me, but that just
I want to be a dragon.
Think that maybe like these AI issues are not really as peaceable as we might be hearing from Karyn, and that the copyright issues at least have not been sorted out yet. We're not maybe ready to peacefully coexist just yet. So Josh, can you tell us a little bit about the current pending cases and maybe how the copyright theories that are being raised, and what we might need to sort out before we get to that perfectly balanced worlds that that Karyn envisions.
Sure, and it's great to be here, and it's nice to hear other people's perspectives because in some ways I think Karyn and I agree. I think that there is a path forward. The problem I see is AI is not a monolith. It's not one thing. You will hear across the panel different issues are coming up because of different kinds of AI. And in fact, different artificial intelligence companies do different things. There's different situations where they're licensing or not licensing. But it's also how they're using the content differs. It also is different in terms of what content they let come out of their artificial intelligence, especially early days and certain platforms who had generative AI. You could get all kinds of content coming out of them. And then over time, they've said, oh, perhaps we don't want to be just giving you all of Harry Potter in one go, and they've started building in more restrictions. So the AI model itself is able to do a lot, and now they're building restrictions around that, I think, to respond to copyright concerns. So it's not like there's one thing in the technology, and there's also not just one thing in the marketplace. So there are companies who are going to sell something that's, here's this tool, do with what you will. And then there are those who are going to sell something that's like, oh, you are a writer. Here is a tool for writing. And it is going to be in direct competition with the people whose content was trained on. That may have different concerns. So let me just leave aside the fair use issue for the moment. Perhaps we can come back to it. But that is like, the elephant in the room. There's no way to get around it. That's going to be a huge decision maker in this process. But what I think has been interesting and sort of from a copyright litigator perspective pushed us a little bit is the court decisions we've had thus far in the class actions that Sandra was mentioning earlier have been forcing us to put our copyright claims in specific boxes of what is the theory, what is the copying that you think is your infringement. Some of them were fairly straightforward. You downloaded my books or my music, and you copied it, and that's a claim on that point in time. That's then used to train, and so then there's been copyright claims to say, okay, in the training process, there are also additional copies being made, or there was a theory that it's compression, that actually when AI companies talk about training, what they're really doing is compressing data down. So those two theories seem to have survived. Those two seem to be, the courts are comfortable with them, at least to get through to discovery. We'll see what's going on under the hood, and we'll come back to it later. But then there were theories that courts got uncomfortable with. The one that I think was the most aggressive, let's say, was the theory that everything that comes out of an AI is infringing at the output stage, regardless of its similarity to the inputs. And that was a theory, and I can understand the rhetorical or the way people got there, which is, you copied my stuff, something came out. That seems like it would be infringing my work. But the court said, no, from a infringement perspective, we look for substantial similarity to the original. So in the first two sets of cases, you can say, it's the whole work. There's a copy made. In the latter case, if there's no similarity between the thing you're saying is infringing and the thing that you're saying is your copyrighted work, it's hard to see the matchup from a copyright perspective. There are other claims that may come into play, but that one doesn't work. And so there have been a number of motions to dismiss thus far where they've analyzed those theories and said, those are in, that last one is out. And then other kinds of claims. We're going to focus on copyright today, but copyright management information is a claim that's been in these cases. One of the cases dismissed it on the grounds that you need to have the entire work come out for there to be a copyright management information issue. This is the, for those who don't know, copyright management information is like the author, the title, that kind of thing. And the outputs may or may not include the names of the people whose works went in on the input side. So the court said, well, it has to be the whole work. Well, one of the courts that decided that said, this is a big issue. This is an important thing. People could differ on this issue. And although I don't think there's a claim, I think the Ninth Circuit Court of Appeals should take it up. So that's been certified to the Ninth Circuit. And we're waiting to find out, are they going to take it and tell us what they think of those kinds of claims? And then the last thing I'll say is, and then there's just non-copyright claims. There's false endorsement and trade dress claims, which I think are really interesting because in the image cases, images will come out with someone's name on them. It literally will say, here's an image by Joshua Simmons. And the artist had nothing to do with it. And we don't have moral rights for every kind of work in this country, for some of them. And the Copyright Office would say we have met our copyright, our moral rights obligations. I might be quoting. Someone at some point at the Copyright Office may have said that. But the way that they get to that concept is through these concepts of false endorsement or trade dress. And the idea is, okay, well, if you're putting something out in the world and it says, by this person, and it's not by that person, that's false. That may be a false advertising. That may be a false endorsement. And so those claims are also in parallel track with us. We're not going to focus on that here, but I find that really interesting that we're sort of pushing all of the different buttons in the IP toolbox to try to figure out, okay, what are the lines? And then I think what will ultimately happen is AI companies will adjust, as they always do, to whatever the law is. And if you tell us we can't have someone's name, they won't. And if you say we can't copy in this way without a license, they'll get a license. And if they say you can copy in this way without a license, they'll do that. So I think there is a natural flow to the system to get to where Karyn's talking about, but it's going to be messy. We're in the United States, we're a messy country. We like litigation, and we'll see these sort of things play out, and then we'll come back and we'll spend the next 10 years debating what those court cases mean.
That wasn't dragon-like at all.
Oh, okay.
That was so kind. That was more like a lost salamander. I don't know.
Okay.
That was sweet. No, that was nice. All right, thank you. That was super helpful. I'm teasing you only because I love working with you so much. So don't take offense. So I want to get all the issues out on the table. So I'm going to move to Professor Justin Hughes, who is the Honorable William Matthew Byrne, Jr., Distinguished Professor of Law, and Fulbright-Hanken Distinguished Chair in Business Economics at Loyola Law School in Los Angeles. And so he teaches courses in IP law, international trade, and internet law. But he's also had a notable career in public diplomacy. He served roles in the Obama administration where he was in a leading role in U.S. delegations negotiating international copyright treaties, including the Audiovisual Performances Treaty. And I think that sets him up to be a really well-positioned voice to briefly share with us information about the recently introduced No Fakes Act. So if you're willing to do that for us, Justin?
I'm happy to do that, and I have 5 minutes to summarize it.
A big bill, yeah, exactly. You can do it.
So many of you have heard about the No Fakes bill that was introduced at the end of July in the Senate and in September was introduced in the House. It is a digital replica right bill, but I want you to think of 3 distinct problems it's trying to address. So the first problem is the problem of privacy and deep fakes, and how we are now moving to a world where revenge porn has become even more vengeful in the forms of deep fakes created of people, particularly women. That's one distinct problem, privacy violations of individuals, private individuals. A second problem is consumer citizen deception. And many of you remember from 2017, 2018, when the University of Washington scientists and Jordan Peele put out Barack Obama digital replicas to show us the potential deceptive power of what the technology was going to bring very shortly. And so that consumer deception, citizen deception is a second chunk. And then the third part is the professional careers part. Now, everyone in the room, is there anyone who's not seen Star Wars movies? So you remember the Death Star, and the Death Star was under the command of General Tarkin, and that was played by Peter Cushing, an actor named Peter Cushing in 1977. In 2016, Disney released Rogue One, and Rogue One, there was Peter Cushing again commanding the Death Star as General Tarkin. And a few of you may have seen that movie and said, is he still alive? But in Hollywood, the real question was, what moisturizer is he using? And in fact, Peter Cushing was way dead, and that was digitally created by using an actor, Guy Henry, playing roughly the same size and trying to mimic Tarkin's body manners and then digitally replicating his face. So there's the professional career element for performers, audiovisual performers, musical performers. There's the privacy component for all of us. There's the consumer citizen deception component for all of us. So No Fakes proposes a digital replica right, which a digital replica, you need to know the definition, is defined as a newly created, computer-generated, highly realistic electronic representation that is readily identifiable as the voice and/or likeness of someone. So if you watch South Park and you see a computer-generated Jay Leno character, it's not a digital replica under this bill because it's not highly realistic. If you see a Robert De Niro with wings and red and horns and a tail and flying as a dragon, it's not a digital replica because it's not highly realistic. If it's Tom Hanks, it's a digital replica of Tom Hanks falsely hawking miracle cures and wonder drugs, as Mr. Hanks has been fighting against. That is a digital replica. If it is a Scarlett Johansson voice or indistinguishable from Scarlett Johansson playing her role in the movie here, and it's used by Alexa or Siri, that's a digital replica. So the No Fakes Act would create this exclusive right that belongs to a person. It is a right that during their lifetime is inalienable, although it is licensable, and then it is a descendable right, which can continue up to the life plus 70 of the individual. And we can talk about those details, but the important part to understand about it is that while it gives the individual an exclusive right, liability, and it's liability for production, publication, dissemination, transmission, display, requires that the culpable party has actual knowledge that it's a digital replica and actual knowledge that it's unauthorized. And that makes this very different than copyright or patent law, right? Where there's liability regardless of your knowledge level. So what the bill really does is it says online service providers will be liable unless they respond to a takedown notice which could give them knowledge. So it establishes a notice and takedown system directed at online providers by giving them a safe harbor, saying you will be liable, except that if you take down or disable the digital replica in a technically and as soon as technically and feasibly practical, that's the standard in the bill, you will be off the hook. That's the safe harbor. So while it is structured as the creation of exclusive right, and that will subject it to the criticism that is duplicative of many aspects of right of publicity in state law, what it's really doing is it's establishing a takedown system to address digital replicas on all three of these fronts in the internet environment. And there's a gazillion bangs and whistles, and there's lots that's interesting about it, and I'm happy to talk about that, but you said 5 minutes, and now I'm at 5:25.
That was amazing. Thank you, Justin. We'll wrap the panel, and we'll come back for more information on that particular bill, but thanks for that primer now. Let me move to Bill Patry and transition a little bit to a couple of different issues that are on the agenda. So Bill is a partner at the law firm of Mayer Brown, where he helps clients grow and protect the value of their assets. But over the course of his career, he's worked in private practice at corporations, including as the lead copyright counsel and policy counsel at Google, and as a senior official at the United States Copyright Office, as well as on the Hill. But most notably, probably to all of you in the audience, he's the author of two of the most widely cited legal treatises on copyright law, Patry on Copyright and Patry on Fair Use. These treatises and Bill's other writings have been cited approximately 1,000 times by federal courts, including many times by the U.S. Supreme Court, most recently in its decision in the Andy Warhol case. I'm personally happy that I'm actually working on an article with Bill on AI and copyright issues. And I'm going to ask Bill to transition us to a discussion about AI and copyrightability generally, and comment maybe on the copyrightability of AI-assisted works and the Copyright Office's recent guidance on that issue. And if you're comfortable talking about the Allen case, I don't know if you've had a chance to to look at that, but maybe just generally on the AI assisted works issue, that would be great, Bill.
Great, thanks. Well, I've done too many things. In fact, my mother was worried that I'd never have a stable job, and maybe I haven't. But at least I've got to, enjoy different sort of ways of looking at copyright. Both from working in the corporate office, working on the Hill, working for Google for 17 years, private practice, things like that. I've yet to settle down. I probably won't. But, it's been a living. What can I say? So what Sandra wants me to talk about, I think, is the role of the copyright office in this. And having worked in the office, I have some experience with it. The joke on the Hill was there was this particular member of Congress who left and went to the Senate, and the joke was that in doing so, he raised the IQ of both bodies. So, I left the office, and then, now it's a better place. This is a good place. But I actually admire the office a lot. I have deep admiration for Rob Kucinich, who some of you may know in person or may know him from the letters that he has written on these AI issues. And he's a great friend and a great scholar and a really sensitive, thorough writer, so I always enjoy what he writes. The current Register Shearer, of course, is a world-renowned expert, as is her predecessor, who's sitting to my right. So, the office is an amazing place, and I love it dearly. It does a lot of things. It does policy things, right? It issues policy statements, guidelines. It advises Congress. You go overseas and talk to foreign officials and try and convince them about the virtues of the American way. So it does lots of different things, including the registration one, which is sort of my narrow topic. What's the office's role in the registration process involving things that have artificial intelligence in some way? And it's an important issue, I think, in this way. I happen to think it's a bright, shiny object issue myself, and hopefully it will go away, and in a constructive way. But I think it's a bright, shiny object that will be dealt with, hopefully effectively. But it's never less important because of Section 411A for U.S. works. It's your ticket to get into court. So if you can't get into court, that's a problem. Of course, if you have a refusal, you can still get into court, but you don't want the Copyright Office on the other side from you. If you get a rejection, you go into court, you sue anyway, the office is likely to intervene, or at least it has the option to intervene. So while I think the AI issues are nice, bright, shiny objects, it doesn't mean they're not important. They are important for that reason. The office's registration role, of course, is a statutory one, and it's a long-standing one, going back to the 1800s. So the office has a great deal of experience on registration issues. It has a lot of institutional memory, as they like to say, on these. And whatever the decisions may be, whether it's a letter that Rob writes or somebody else, it's not a personal thing, right? We shouldn't say, oh, Rob Kucinich wrote this letter, and how could he say that, right? It's an institutional thing. So when we're talking about these, even if you're talking about a letter that somebody wrote, I think it's important to understand that these are institutional issues and not personal ones. And I say that because I actually don't agree with the office's current approach to it. So I just want it to be understood that I love the office, I love the people who work there. They're amazing people as people, and they're amazing experts. I just happen to take a slightly different approach to it, and that stems from my own personal predilection for what the office's role should be with respect to registration. All the other stuff, of course, is different. The policy stuff that they do, the administering, the Small Claims Act and compulsory licenses and the reports, those are all amazing, great things, and those are fine. But we're talking right now at least about what the office's role in registration should be. So, cut to the point, my preference is that the office abandon its current disclaimer policy. I think it's mistaken. I think it's not helpful. And it's also contrary to the office's prior practices. So from 1988 to 1992, the office did have a disclaimer practice for one particular type of work, and that was computer programs that generate typeface. This was an issue because typeface is one of the few subject matters that Congress decided not to protect in the 1976 Act on behalf of authors and publishers who were worried that the printer would use an unlicensed typeface and then there'd be an injunction against the book. So Congress chose not to do it. It originally was going to be a part of a Title II in the 76 Act on the design of good-looking toasters and other sort of useful objects, but it was cut. The Senate had passed it, the House didn't. So typeface has been excluded, and the concern, at least of the General Counsel of the Copyright Office at the time, was that if we grant protection to computer programs that generate typeface, we'll be giving backdoor protection to typeface, which we're not supposed to do. I don't know that that was really the case. I don't think it was, actually, but she thought so. And so she prevailed. And she prevailed in the sense that these programs had to disclaim typeface, even though you were saying that the subject matter that you were asking for was a computer program. You nevertheless still had to disclaim typeface, even though you weren't claiming typeface, right? So eventually in '92, I convinced the registrar then, Ralph Ullman, to abandon that. And we had a hearing about it, and the office decided that it was not a worthwhile policy to retain. Never should have been in the first place, but having had 4 years' experience, okay, you can see how it works out. And the office decided it was a failed experiment for a few reasons. One of which, administratively, it was a problem for them. The other one, I think, was a recognition of what the office's rather modest role is, and that is to register works that contain a minimum amount of registrable material. And beyond that, the scope of the registration, the scope of the copyright is up to the courts, not to the office. And I think that's true for everything. So what happens is, someone files an application. Let's say they're going to file an application for a motion picture. And it comes in, to the office, and, there's the deposit copy, there's the application, there's the money. The money is siphoned off to someplace else. And then, the form, PA form goes to the examiners, and they watch a little bit, and that's it. And same thing for books. You're not going to have the examiner sit and read an entire book. They don't have time to do that, and it wouldn't do anything anyway. There's clearly enough registrable material there. So you look for the minimum amount of registrable material that there is, and then if it's there, you stamp approve, and it goes on. And that's it. And that's the role of the office. There are cases where people claim unregistrable material, ideas, methods, facts, things like that, and then you have to correspond with them and say, no. Please amend your application. The answer is no for that. But where somebody does not claim anything that's unregistrable, and there is a minimum amount of registrable material there, to me, that's the sole role of the office. You approve it, and you move on. And then you let the courts and the parties fight out what the scope of it is. And they're much better suited than the office to do it. Not because the office doesn't have expert people, they do. That's why I preface this. They have amazing people. It's a waste of their time to do that. It's not necessary. And in the discovery process, you're much better able to figure these things out. And that's particularly true, I think, for AI, for all the reasons that Joshua gave too, because it's a heterogeneous tool. It's not a homogeneous tool, and it's going to vary. And it's not the role of the office to go independently determine what sort of a tool you use for that work. They're not suited for it. It's not appropriate for the role, and it's certainly never appropriate, I think, to make people disclaim things that they're not claiming. That's why I said, if you claim something you shouldn't, of course, you're going to get smacked down, and you should be. If you're not claiming something, you shouldn't have to say, I'm disclaiming the use of this tool, or I'm disclaiming this or that. That's just not what the office is suited to do. It's not what we want it to do. We want the wonderful adversary system where dragons like Joshua can go, duke it out and breathe fire and, vanquish all the bad guys. So I'm going to stop there. If you want more details, there's an amazing submission that was made to the Copyright Office that spells all this out in great detail. And it was written by Karyn and the amazing Tara. It's the Motion Picture Association submission to the office on these, so I would refer you to those.
Thank you, Bill. And we'll move to Bijou Mgbojikwe, who is Senior Policy Counsel at Entertainment Software Association, where her role is to expand and protect the innovative and creative marketplace for the video game industry. And she is the perfect person to end the panel's first interventions with, because she is a person who can put thorny topics into a really practical, real-world business perspective. And so I'm going to ask her to do so by giving us some examples of potential uses of generative AI in video games and making a positive case for generative AI use for us, maybe playing off of a little bit of what Bill told us, why should generative AI works be copyrightable.
Thank you, Sandra. I'm very happy to be here. Thank you, everybody. I will just start to say that unlike other sort of creative industries, video games are unique because we've already been using AI in video games for decades. So although there's a lot of concern surrounding generative AI, our position is that sort of generative AI and non-generative AI tools should be treated like any other software. And I'll give an example of a non-generative AI in video games. And that is, for example, something small. The shape of NFL jerseys in Madden NFL 21. A lot of people take things for granted when you're looking at a game, but a lot of what's there is problem solving, and it's about greater player immersion. So what your game jersey looks like when your player is standing still, when your player is running, when your player has been hit by something, all those deformations are machine learning. And that output makes the game feel more realistic. And sort of AI tools used in video games is about two things. One is allowing developers to focus less on sort of tedious tasks and more on creative tasks, but also heightening player immersion. So generative AI does all those things, but it can do it in a way that, like I said, allows developers in particular to focus on things. And I'll give you two examples. One example is around script writing. So one of our members who has an R&D team developed an AI script writing tool. So for an open world game, and we have quite a few of those, this is a game that never ends. Levels keep going. They can be up to 100,000 lines of dialogue. And a lot of that dialogue is by background characters. They're called non-player characters, or NPCs. And the dialogue that NPCs emote are called barks, as in dogs barking. So the AI script writing tool can allow non-player characters or the writer itself to generate an extensive volley of barks so that you don't have to spend all your time writing script for secondary background characters, but you spend more of your time on developing storylines, narrative arcs, and just general narrative design of the game world and of your characters in that world, because the world keeps going. and those characters meet players. So their interaction with players is where the concentration is in now. So one of our companies debuted this year their experimentation with generative AI. And this particular experiment allows them to sort of prod at the limits about how a player can interact with a generated character, but without breaking your immersion in the world. So the character doesn't lose sight of the fact that it's in a particular space. It's trying to get you to join its mission in a revolution against, big bad corporations. But what it means for the writer is that you have to shape the personality of the character. So you have to create their backstory, you have to create their conversation style, and you have to basically create a personality. And you train your large language model with all those and allow that language model to improvise dialogue. So you can converse with a particular character that has a particular backstory. And when you put them in context, you can ask them questions and they will draw on that backstory and converse with you relatively intelligently. And this has been an interesting experiment that can be used in video games sort of going in the future, but also like immersion experiences. And one of the things that non-player characters do is that although they're not necessarily primary to the plot line of the game, they simulate, a vibrant sort of living world. And that is what we want to be able to protect. Copyright is incredibly important to video games in particular, and we think that copyright really, how it drives innovation can really be demonstrated with video games. So after the 1976 Act passed, that said that computer programs could be protected as a literary work, it was followed by decades of litigation, but particularly in the 80s, where defendants who were copying and infringing others' video games on the market threw up all kinds of arguments that video games were not fixed in a medium of tangible expression, they were not original works of authorship, that the computer program was actually the author, that it was really utilitarian because the program and the audiovisual display were inseparable. Fortunately, courts rejected those arguments and said we really have to focus on sort of the quality of the human contribution, the creative process, and that software tools are really a way to express your creativity. And as a result of that, the industry, for those of a certain age in this room who sort of came of age in the 90s, and I'm dating myself, that's really sort of the video games that we know. The Super Nintendo games, the Capcom games, those types of games, that really came into development as a result of the settling of copyrightability of video games. So we take for granted now that video games are copyrightable, but that wasn't always the case. And we think that a lesson may be sort of learned from that experience now. Games have always challenged sort of copyright law and the boundaries, and we think that's what's happening here. But I'm not predicting the future, but I think there might be reason for optimism in terms of protectability of output when you really consider that you're using a tool to express your artistic vision. So we would like there, not to sort of think about bright line rules or rigid analysis, but really focus on sort of the quality of the human contribution.
And are you worried about the same sort of issues that Bill is raising, that if you are required to disclaim the use of AI elements in creating video games, that you're going to be unable to protect video games as a whole or in part, or that the development process will fall apart if you're forced to live under those guidelines?
Well, yes. I mean, for some video games where, to some extent, the algorithms in the game are generative, it's hard, first of all, to disclaim or figure out how to disclaim regular non-generative AI algorithms from generative AI algorithms, and also figure out how to separate sort of protectable audiovisual output from the underlying algorithms, but then to say that the audiovisual display is somehow not copyrightable would be a big problem. Like we've said, copyrightability has driven not just innovation, video game industry, but creativity and innovative creativity. And we would be really concerned if all of a sudden the way the industry is sort of moving forward in this sort of innovative way is no longer copyrightable. And I think that would be a really troubling result for us.
And I see Karyn nodding. And is this the sort of balance that you're alluding to as well in your opening remarks?
Yeah, I think that's exactly right. There are a lot of similarities, obviously, between video games and motion pictures. Video games now are basically motion pictures in some sense. But I think that, just on the copyrightability front, the complexity in terms of how both video games and motion pictures are created really leans against a very rigid application of copyrightability and a more nuanced application of the general framework we already have in the law under the Cerrone case in terms of what makes up human authorship. And I think where some in the content side are concerned with respect to the guidance that's currently out there is that there appears to be a more rigid application, I think, in a rush to provide guidance because everybody really wants to know how can you file your registrations now? Are there different changes that we need to be aware of? There seems to be a more rigid application of copyrightability, whether it's, if there are prompts, that means, it's generative AI and it's not copyrightable, as opposed to looking beyond just the use of prompts and how those prompts were actually influenced or used by humans and what other additional human authorship might have been involved, as well as just the issue of disclaiming. I think, yes, the office for decades has required you to disclaim public domain work and other works that you didn't create in the registration, but a kind of not knee-jerk, but a overly simplistic requirement that you disclaim AI in all works will just lead to, I think, creators just putting a simple tag on their registration application that says we disclaim whatever AI is in there, and you don't actually know what AI is in there, but you're doing it as a protective matter. And I think you really do need to figure out, is it really truly an AI created work, which is really what the office is concerned about, versus whether there was some use of AI to create the work, which is permitted just like Photoshop is permitted. And you don't disclaim use of Photoshop in your registration. So I do think that there's just going to need to be some nuances in terms of the application of the pre-existing standards based on the types of works that are out there and the complexity of those works.
Sandra, can I make an observation?
Yeah, I see. Go ahead.
One of the things that I think is so interesting about the copyrightability registration issue is this disclaimer requirement that the Copyright Office is using is, in my view, inconsistent with how it looks at works in every other context from the perspective of they usually don't care what your process is. Modern artists have for years been very frustrated because the Copyright Office rule was we look at the image on the page and we say, is that enough? If it's a red box and you say it's the sunset at the whatever and I did all this stuff and I imbued it with my creativity, the Copyright Office would say, I don't care, that's a red box, that's not creative. They are now asking you to get into the methodology by which the thing is created, and I don't think we do that anywhere else, and I don't think that they want to do it anywhere else either. So that, I think, is odd, as opposed to the normal role they see themselves as playing, which is comparing the existing work to, as you said, Karyn, pre-existing material and saying, is that too similar? And from a practical perspective, people want to start using this material both in these industries, but also source code and other situations, and people don't know what to disclaim or how to record what they're supposed to be disclaiming. I have a lot of clients that say to me, I'm writing code using generative models. Do I have to put something in the comments that says this part generated? And do I have to say, and by the way, it was generated like this, and then I added to it in this way? Like, what am I supposed to do in a litigation when we show up and say something was disclaimed, and now, like, how am I going to show what that is? So there's several practical problems with that approach. I get the desire to not register all these works because some of them aren't doing enough, but I think there is a practical issue there.
Going back to no fakes?
No.
Yeah, okay, yeah, I think Justin has a comment as well. And then,
So I agree that there's a big distinction between the Thaler case where someone's claiming, I want registration of a computer-generated or AI-generated thing, and the situations we're talking about. But I agree with Karyn, disclaimer practice is quite real, and it's been there for a long time, and I will give you a funny example of that. So every few years, I actually register a law review article, figuring I teach copyright, so I ought to know how it's done. And a few years ago, I got back an email that said, it appears to be a bunch of stuff in this law review article that's not original. That is, I quote other people. And, and we need you to disclaim all that. I'm happy to disclaim Pam Samuelson's words, but that's a separate issue. But the disclaimer practice is real, but the difference here is that when you have an Ansel Adams photo of Yosemite, all of us know the pre-existing material, and we know what Yosemite looks like. And when you read a law review article and the professor quotes some other people, you know what the quotations are, and you can go back and find them. But I do agree with the problem that the Copyright Office is pushing themselves into a corner, but I am sympathetic to the problem in that they're dealing with a set of applications for works where there is a significant part of the work that cannot, through external evidence, be identified as pre-existing or not pertaining to the author. And that's a different dilemma than with photography or with text-based works. That's a real dilemma. And as they grapple around for finding a way to get a policy to deal with that dilemma, I don't know the answer, but I want to say it is different. It is different than photography. It's different than textual works, where you can go out there with external evidence and identify what does not pertain to the author. So I am sympathetic on that, and I'd be happy to read you the email from 2017. I was really shocked when I got an email from the Copyright Office that said, looks like there's stuff in here that's not yours. You need to disclaim all that. But I disclaimed it.
yeah, go ahead, Bill.
Well, I mean, to me, that was just stupidity. I mean,
Mine are
really.
Wait a minute now. I was at
Really?
the Copyright Office in
I mean,
2017.
someone had too much time on their hands. Should have been doing other things. I think we also have to distinguish between derivative works and non-derivative works. Every application has a space where, if it's a derivative work, you have to say what the pre-existing material is and what you added. And you do it in a really cursory way. So the derivative work stuff is really not what we're talking about, and that's dealt with in its own way. I mean, I'll use stupidity twice, and that's the Thaler case. That's a cheap stunt. And it was a cheap stunt that got us down a road that we shouldn't have had to go on. But we're here. And so, the issue is, yeah, as Justin said, these are complicated issues, and complicated issues should be dealt with in the appropriate forum. and the appropriate forum is in no way, shape, or form the Copyright Office. That's just not the rule. They're not suited for it. They're suited for many wonderful things, and I love it dearly, but they're not suited for this. We don't want examiners or even the appeals body to be figuring out, did you use this prompt enough or that prompt enough? Was that creative enough? They're not suited to do that. They shouldn't be doing that. Life would be much simpler for them and the rest of the world if you just left it up to the process that's already there and that will be used anyway, which is the court system. I'm appalled by the idea that we want the office to get involved in making that granular of a creativity analysis. They've never done it. They should never do it.
So as much as I love this topic personally, I don't want to get bogged down on this one issue, and I'd like to follow up on some of the other topics that came up, and I also want us to involve the audience in discussion. So if there are questions from the audience, come up to mics, and I'll recognize folks with questions from the audience as we go. If I don't see people at the mics, I'm just going to keep asking questions up here. But one of the questions that I wanted to follow up with Josh on was to raise the question of fair use issues. Do we think any of the cases that you mentioned are going to actually be resolved on fair use grounds, since that is one of the favorite defenses that comes up, and it's been raised, I think, in all of the cases, right?
Yeah, I mean, I think a fair use decision is inevitable. The question is going to be, how did the courts deal with it? As I said at the beginning, I think that there is a world for a more nuanced approach to deciding these cases than, we're just going to say this, all this technology is out or all this technology is in. But multiple cases have raised it. There's a case that against Anthropic, that there's a motion for preliminary injunction pending. The argument, I believe, is now set for next week. So that seems like the court's getting ready to rule in that case. Although in the preliminary injunction context, they have many off-roads by which they can reach a decision that doesn't actually decide the core issue people are waiting on. But in another case, we're representing Thomson Reuters against a company called Ross Intelligence. Thomson Reuters creates Westlaw and has a large amount of content, head notes. The Patry treatise is actually a part of the Westlaw database, but head notes and summaries and the West key number system. And this other company, which was creating its own legal research platform, hired a third party, came in under a contract that they were not allowed to do this, but came in under a contract and then scraped Westlaw. They then took that data and used that to train the model that runs their legal research platform. We had already moved for summary judgment. The judge said, factual issues, let's go to trial. And let's have a jury decide. How much do you like fair use being decided by juries, much less by all the people up here who probably don't decide on that issue? And then the day before the trial was supposed to start, the judge said, you know what, I want to grant Josh and his team more summary judgment. And the defendants, I suppose, wisely said, oh, you can't just do that. We need to do lots more briefing. We should not go forward with this trial tomorrow. And the judge says, well, I guess I'll do that. So we're pulled back. We were literally in Delaware, ready to go. And the judge said, let's do more briefings. We are now in summary judgment briefing again on direct copyright infringement and fair use. And it sounds like the judge is now ready to make some decisions. He has come around to the idea that fair use is to be decided by the court, and he wants to be the one who decides it. So I do expect at least some kind of a ruling from him in that case. And then there's all the other ones that are probably too early for us to expect anything anytime soon. They're mostly in fact discovery, and so are at least a year or two away from summary judgment briefing. But any one of these cases could have a fair use issue because at the end of the day, the copying's not really going to be disputed. There was a theme of we're not copying that I think has largely been abandoned in the face of reality. And now it's really going to be, was this fair use to do or not?
Can I add something on that? I would just say, I think, obviously totally agree with what Josh said. I will say that even when we get a case on fair use, obviously, that is not going to decide the issue completely. As you mentioned, there are 30 other cases. But I think the one thing that we have to, again, guard against is this kind of knee-jerk, again, reaction to wanting to have a really clear set of rules and therefore making blanket statements about fair use and saying, yes, this is all fair use, or no, it's not, none of it is fair use. And so I think we just need to make sure that we're, when the first case comes down, it might come down that it says it's not fair use, or it might come down it says that it is fair use, but you're not going to then be able to say that next case or that next platform is able to do what they're doing, because obviously fair use is a very specific fact-based analysis. And so I think people really do want to have an answer. They want to know, can I do it? But the robustness of our legal system is that fair use is a flexible framework that you have to apply to individual factual cases.
All right, I want to move to the, I actually want to move to the questions from the audience so that we can involve folks and from the audience as well. So if you can identify yourself for everybody and for the folks that are going to see this on
Sure.
YouTube.
Hi. Oh, it's working. My name is Farzad Benshiri. I'm a trademark and copyright attorney with Cantor Colburn and an alumni. So I just wanted to follow up on the point of Josh regarding methodology. Another way or another perspective of seeing it is maybe the Copyright Office is not checking the methodology per se. They're looking who is actually creating the artistic work. Like we got the monkey picture case, and in those cases, the Copyright Office said it's not an actual person, not copyrightable, and I believe, so I did not follow the AI track of too much, but I remember that the Copyright Office had something published where they were saying that it's basically it's not a natural person, it's not a person, so that's why we don't think it should be copyrightable. So just to follow up on that, do you agree or disagree, or do you think that, I mean, it's kind of merging together into an analysis how a work was created, but just from a different perspective?
Yeah, I mean, you're correct. The Copyright Office for many years had said animals can't create things, divine entities. Some people would say, like, a divine entity had me write this, and if you say that, then you don't get the registration because you didn't create it. But that is a question of the author. So when you fill out the registration form, you have to say, here's the author. The disclaimer comes in the pre-existing material box. And so it's not actually asking the question of who the author is, it's asking what did you create? And again, for years what the Copyright Office has said is, I don't care how you did it, I want to know what is in there. And so that's why I think there's a little bit of tension. I think the other way to deal with that would be to go down the 103A or 103B line, which is 103A and B are basically, if this is a derivative work, you can't own the parts that weren't created by you, or if it's created unlawfully, you can't own it. And so there's an argument that if you start getting cases that say AIs who copy are unlawful, then nothing that comes out of them that was not licensed is going to be registrable or copyrightable. Or that if they have material that you can see on the front of it, like if you put a Mickey Mouse, sorry, Karyn, in a AI-generated image, then I think it would be fair to say you should disclaim that because you didn't create Mickey Mouse. So I think there are ways to go about it that that get to the same place, I think, that they want to go. But I ultimately worry about the conception of authorship that they're using, that it's a little bit narrow from my taste.
Thank you.
And the next question over here, and then we'll go to the question over there.
Hello, my name is Ryan Cavanis. I'm a first-year law student here at George Mason. So I wanted to ask a little bit more from you, Ms. Temple, about, you had mentioned in your initial part of the panel that you want to see an equitable way for both generative AI to be used, and for those who create the works it's based off to be fairly compensated. Now, one of the problems, and I think you and Mr. Simmons were starting to talk about this, is the fact that we have this question of fair use over the training data used. Now, I know some of that is stuff that's scraped off from the internet, but I know Anthropic, at least, and a few other major companies, but especially Anthropic, had actually used pirated data, I think from Z Library, I could be wrong on that, just having that data by itself can't, they didn't come about legally. So when we look at, in terms of remedies for the people who were affected by that, what do you think should be done to compensate those artists and other creators who've had their works pirated, and now you have this model, and you can't just take out the data that was used to train that model?
Yeah, I mean, again, I think that you're going to apply the standard copyright rules that we have. You're going to analyze whether it is in fact fair use. You're going to look, especially at the fourth fair use factor, the effect on the market or the potential market. And I think that those factors are going to certainly play strongly into whether the use was a fair one, or whether it's infringement. And if it's infringement, there should be compensation, and there's going to be liability, and they're going to have to compensate. And I think you do need to, guard against blanket rules that would allow for, I think certain types of conduct that would undermine the value of folks' works. I think, for example, there are some countries that were actually in their rush to encourage specific exceptions that would allow certain use of copyrighted works for generative AI. We're actually, creating specific exceptions that would allow pirated use of, creative works. And that clearly is not something that should be encouraged by any government or court. So I think that, we again have to just take a very balanced approach to it. And I think that, in the case of the use of pirated materials, I would say, but maybe the others will disagree with me, I would say that most would feel very comfortable that's very unlikely to be a fair use. And certainly that specific exceptions that are being considered in other countries around the world, like Japan, should not enshrine in their law the protection for the use of pirated works for purposes of generative AI. And at the end of the day, I think, you look at the solution is, potentially licensing. And, right now, there are over a dozen publicly reported license deals that have been done between various content industries and AI platforms. So it's not an issue of there being no alternative other than taking a work without permission. You can go to get permission, you can develop a license and still be able to utilize that work, and that's where we're able to see this licensing market take off with respect to generative AI.
So Karyn, you raise actually two good points that we were talking about in prep. One is this taking data out point, and there are companies like Scale AI that do like data tuning and that sort of thing. Do any of the panelists want to comment on companies like that?
Yes, Ryan, the idea that you can't retrain the model is false, right? And we're all the time taking out data sets are constantly being revised to remove duplicates, to remove pornographic material. And there's every reason to believe that the large AI companies are retaining full copies of the training data for precisely that purpose. Over almost a year ago now, there was a paper from Microsoft researchers on detraining models on Harry Potter, removing all the Harry Potter stuff. So the idea that they've built and trained the model and can't go backwards is false.
And a question over there.
Hello.
Hi. Thanks.
Thanks so much for being here. My name is Jaden Klubeck. I am a second-year law student at the George Washington University. And my question involves a familiar topic about tech companies. So let's say you're advising a tech company that has a AI model. Let's say they have a large language model as well as an image generating model. How would you advise them to reduce legal liability? Thank you.
I would advise them to go approach the content owners and get a license. That's me.
Or use public domain material.
Or use public domain
You know,
material.
there's a lot of public domain material that people would sort of ignore. You know, the government works. There's a lot of material the government's putting out there, images and text that people can use. But in terms of if you're going to be using unlicensed material, I'll go back to where I started, which is we can have a whole debate about whether using that at all is a problem. But from a practical perspective, there are many things you can do to prevent people from using inputs or generating outputs that show infringing material. More safeguards that can be put in place. And a lot of the AI companies are now doing that, I think, in response to the lawsuits that are happening. If you now see in a lot of them, you can't say, in the style of certain living artists, for example. That was a decision some image search engines made. In the text-based ones, if you ask for, give me all of Harry Potter, it'll hang and say, I can't actually do that for you. I don't think that solves the problem because of the licensing market failure that you're hearing from Karyn. But if you're advising the client, and we're talking about sort of how do I want to set up your system to be not the first one on the lines as we figure out what the law is, doing those things can help, because then you're not the bad actor in the view of those who are feeling like they're not getting their paid, frankly.
And just to follow up on, I kind of said get a license. That's the easiest thing for you to say in terms of as a lawyer, just in the sense that you don't know the answer. And, again, fair use is a specific, case-by-case analysis. And so if you want the least amount of risk for your client, the most protection, then you would argue you might have a fair use, but it also, if you really want to make sure that you are not going to be sued, see if you can get if you're not using public domain work or work that, you clearly can say is going to be a fair use, then go get a license. And I think often now what we're seeing is that those are the best data sets anyway, that they actually help the AI platforms the best because you have curated data. And we've talked about garbage in, garbage out in terms of AI. And so that if you actually are able to get licensed data sets, then you're actually going to be able to benefit your AI platform better than just randomly pulling in everything that's on the internet.
But let me turn this around on you guys. You're all saying, oh, go get a license, go get a license. But to some degree, doesn't that start to weaken the fair use argument overall on the AI companies' sides if everybody's doing license deals? What does the panel think?
The more licenses there are, the weaker the fair use argument is. But Karyn, just because it's licensed doesn't mean it's curated. I mean, Reddit, right? All of Reddit has been licensed. Surely you don't consider that curated.
I don't work for Reddit, but I will say that there is a lot of curated data in the film industry.
Well, and there are tags and other information in Reddit, but I agree. Like it is going to weaken the fair use defense, but that's okay, because from my perspective, if you actually got a licensing model that worked for the AI companies and worked for the content creators, that's a good thing. Like, I'm not actually an advocate of, we should just have one side win and one side lose.
Right.
That's actually not good as a policy matter. So if you can, and this is an interesting dichotomy with some of the other fair use cases of the past where it really was, stop, I don't want you to do this. What you're hearing from a lot of content companies is, we're okay with you doing it. We just want a piece of that pie.
Yeah.
And that, to me, is a suggestion that there is a way for the market to form and for then everyone to benefit from it. And those who don't want to benefit from it won't. But but there are plenty of other people who seem to be okay with participating.
Yeah, and obviously the other point is, right, I mean, fair use is an affirmative defense, right?
Right.
So you're admitting infringement if you're using that defense.
Right. So
right?
It's a risk analysis. If you're really advising a client, it is do you want to take the risk? The one way to ensure that that risk, you won't have the risk of being sued is potentially to, actually get affirmative permission and get that license. But if, during the analysis you really feel that, in this particular case, after analyzing the 4 fair use factors, you have a strong fair use defense, then you would more likely advise, let's utilize fair use and use the works. But again, it's going to be, I think, individual to the platform and to the user. Can you defend against a potential claim? Is going to be something that you're going to have to discuss with your client. What is your level of risk? Is it easy to get a license? And do you need to have a more curated data set? Obviously, in terms of fair use, the film industry uses fair use significantly, for documentaries and then parody and satire. So, again, we don't want a blanket, all or nothing approach. It really is going to be a situation where you're going to have to analyze the particular use in the particular platform.
So I see Christina is ready to chime us out, but I also see that Jeff is standing at the mic, so I don't know which one to choose here. All right, so last question from Jeff.
So as was briefly mentioned by the panel, we've seen the rise of the regime of the opt-out for AI data training, and that is enshrined now in Article 3 of the digital single market in Europe, and now we have OpenAI announcing that it's creating an opt-out database that you have to go register for in order to opt out. Copyright those exclusive rights would require an opt-in. What does the panel think about the necessity for creators to go opt out in all these separate places throughout the world in order to not have their works mined?
We need the development of something like the TXT, robot TXT metadata that tells you. Problem right now, technically, as I understand it, is we don't have a don't crawl for search, but don't crawl for AI. That's what we need. So we need that kind of metadata in HTML, agreed upon standard, so that opt-in, opt-out becomes just not really the question. So I think the robot TXT answer is the right answer, but we just don't have the as I understand it, the standardized metadata we did a few months ago.
It's also a bit too late, by the way. Like, as Justin said, they already have everything that was on the internet. So they're not going to go, you can't go back in time. So it's a little tricky now to say, I'm going to post something with that. They need to provide those mechanisms for people to get it out of the reach when they retrain. There's no other way to do it.
Other views? Bill, Karyn?
I mean, obviously there are, as mentioned, there are other jurisdictions that have already adopted an opt-out. I think if there is a jurisdiction that has already adopted an opt-out, I won't get into whether that should be something that folks should propose. I think you need to make sure that opt-out regime is effective, easy to, that it allows creators to be able to easily opt out and is, again, recognizes and is subject obviously to the 3-step test and is not overly restrictive.
But the concern for individual authors is huge, because it's easy for us to say, go on opt out. But like if you're an artist, a photographer who's not in this room paying attention to this great panel, do you even know? Like, are they paying attention enough to know what to do? And then how do you go to every single AI platform out there? So I think you do need at a higher level a standardization or legal legislation to help people, because at the end of the day, a lot of the people who are being copied for this process are not big companies. They're individuals, and I do worry about that.
All right, everybody, help me thank the panel. Thank you.